I literally just pulled up where like Bryce and everybody was, and like we were just chilling, and cops pulled up and they just put me in handcuffs. Like I'm in the back of the police car.
Whose shirt is this? Yours? How old are you? Don't lie to me either. 17. Sit down. Where are you standing?
We're here, sir.
Is that out of Florida? You ready?
That's my shirt.
What's your first name?
Antonio, A-N-T-O-N-I-O.
Middle initial?
James.
Last name? Alright. First name?
Ma'am.
Officer Salas. Will you 1015 her, please?
Over here to your right.
Yep, this female. She's going to go with us for possession of alcohol under 21. And wait.
It's on your back.
17, 18. Alright. Put her in the back of our car, please, and get started on a 707 for her.
Understood.
I'll search her in a minute. Do you have any weapons on you?
I have a knife in my pocket.
Right, left foot, left.
Right here.
Okay. Can I give this to one of your friends?
Yeah, you have to
Justin? Alright.
Let's throw it in the truck. You came here in this truck?
We'll just give it to Justin on the back. Justin. So we're charging her with possession of alcohol under the age of 21. So just get started on that 707. You know our back little window slides up and open and close.
Mm-hmm.
All right. You can talk to her through there. Just put her in the back seat and get started on the 707 while I deal with the rest of them.
Understood.
Sounds good?
Sounds good.
On October 23, 2021, officers in Daytona Beach, Florida made a custodial arrest for underage alcohol possession under Florida Statute Section 562.11. Under Atwater versus City of Lago Vista, 532 U.S. 318, 2001, the Supreme Court held that a custodial arrest for a minor offense is constitutionally permissible when probable cause exists. That standard is satisfied here. Florida Statute 562.11 does not require proof of consumption, possession, or physical control of alcohol by a person under 21 is sufficient. However, constructive possession requires more than mere presence. The prosecution must prove the defendant had knowledge of the alcohol and the ability to exercise dominion and control over it. Proximity alone does not equal possession. When the subject disclosed a knife before the search, that voluntary disclosure satisfied her obligation under Florida Statute Section 790.06 and was both legally sound and tactically cooperative. The officer's decision to transfer that knife to an unscreened third party at the scene, however, is problematic. The weapon had potential evidentiary value. Its transfer introduced an uncontrolled variable into an active multi-subject scene. The defensible protocol is to retain a disclosed weapon until the scene is fully secured and evidentiary value has been assessed consistent with standard evidence preservation doctrine.
4X-ray 12 essential.
4X-ray 12.
Adult female 1015. And like I said, I'll search it just so I can get all this stuff.
4 Delta 13, you're reading.
We're going to stick your phone back in your pocket, okay?
What's that, ma'am?
Can I give Justin his card?
Where are the keys at?
My pocket.
Which one is Justin?
Right there.
If you want to hang out, you can. But
Thank you.
I'm just going.
Actually, you know what? Hang on one second. Just turn around for me real quick.
Alright, just hang out for a second, okay, ma'am?
Officer Salas,
Bags in there.
will you
Want me to move those?
bags? I got it.
I got it.
Right in the back for me. What the fuck? They're pretty much getting it. Alright? I'm not even anything. Like, I'm not even, like, I literally not even pulled up and I just,
Go ahead.
4-8 Alpha Hotel Victor. Down
like, I'm in
Dodge
school.
Pickup White Color.
Like,
It's
I don't
valid.
need this shit for me. This is not
Copy.
me. Like, I didn't, like, what the, call mom.
Central 402, 10-4 check.
Mom, I literally just pulled up, where, like, Bryce and everybody was, and, like, we were just chilling, and cops pulled up and they just put me in handcuffs. Like, I'm in the back of the police car. Like, I don't know, like, they wouldn't let me call you, like, I don't know, like, this is all crazy. It is in Daytona. I will send you my location right now. Hold on. No, I think they're taking me to the police station. Like, I don't know. I don't know, Mom. Like, I don't know. No, they said I'm an adult. Like, they don't care about you. Like, I'm an adult. Like, I don't... Nothing! Literally nothing! I literally just pulled up 2 minutes ago, Mom, and all this is happening. Like, I just pulled up. Like, I just pulled up, Mom. I did not do anything wrong. I promise you. I swear on God, on my dad. On Dad's dad. I swear to God I didn't do anything. They won't tell me anything. They just put me in handcuffs. I was sitting on the back of the seat doing nothing. I don't know. I don't know. They don't want to talk to you. They don't care.
4 Echo 12 Central and Alpha
It's my
21.
officer. It's my mom. Can I talk to you? Like,
Ma'am, what's up?
my mom says it's her car. She wants to talk to you about her car.
Alright, just give me a minute.
Okay, I don't mean to yell at you, sir. I
No,
don't
you're right.
mean to.
You're alright.
I just never been inside of a cop car before. Like, I don't do this. Like, I don't do this.
Regarding the subject's phone call after arrest, under Miranda v. Arizona, 384 U.S. 436. The Fifth Amendment right to remain silent attaches at the moment custody begins. No Miranda warning was captured in the available footage. If warnings were not administered prior to questioning, any statements obtained in response to interrogation may be subject to suppression under the exclusionary rule. Statements spontaneously made to a third party, rather than in response to officer interrogation, generally fall outside Miranda's protection. The phone call content remains potentially admissible. Florida Statute Section 901.25 requires that a person under arrest be notified of the reason for detention and afforded the right to communicate within a reasonable time. The arrest notification was given clearly. That requirement was met. The custody transfer was executed in conformity with standard protocol. The transport officer exchanged restraints, confirmed identity, and proactively communicated the forthcoming process to both detainees, a practice associated with reduced resistance and improved custody outcomes.
I'm just freaking out because I'm in handcuffs. Like, I've never been in handcuffs. What?
X-ray 20.
South Atlantic and Harrison, Florida, Golf
5530.
India 59 Black.
Let go. No. You're being arrested and you're on your phone.
I'm sorry, I was talking to my mother. I was letting her know what was happening.
You're 18 years old, right? You're a grown adult.
Yes, ma'am, but I just turned like 18.
What's your first name?
Courtney. Courtney. Rita. Rita.
What's your last name?
Chase. Chace.
And what's your birthday?
09/05/2003.
Did you run her in teletype page? Or in Elvis at least?
I have Paige and
Okay.
Elvis, yeah.
This is Courtney. Here's Courtney's phone. Actually, let me
Okay. All from the same car?
two in this one in that one.
Okay. I guess for the same arrest, I'm guessing.
They're all from the same call. They're arrested for different things. My two are for possession of alcohol, and that one's for weed.
Cool.
So
At 7:07, they're about done.
they're all done. They're all signed.
Sweet. All right, let's go with the girls first.
Okay, so the girls are going to be in this car.
Sounds great.
Both are in the back seat there.
How you doing, young lady? I need you to step on out for me. Here's what we're going to do. We're going to turn around. I'm going to swap out those nice pretty handcuffs for my ugly ones.
Please.
Well, they're going to not feel any better, so
Oh.
it's not going to change anything. Other than he wants his nice ones back, he doesn't want my crappy ones.
That's right.
I'm not going nowhere.
I know you're not. Alright, once we get you to the jail, or actually once we get you to the office, we're going to get you out of these things, do some paperwork, and then we'll get you out to the jail and get you out of here. Alright?
Okay.
Short and simple to the point. I am not here to be an asshole to you. If you're not an asshole to me, we'll get along just fine.
Oh, I'm
right?
very respectful.
Okay. I appreciate that. Alright, come on down here. Come on in, seat over there if you want them, let me know. If you're not, fine by me. Okay. One down. Top, right. Same thing I just told her. I'm here to be as easygoing as possible. So as long as you're nice to me, I'll be nice to you. Sound fair? Alright. Here we go. Take these up. Give it a second.
Yes, sir.
Watch or something over there.
No, I just have
There we go.
bracelets.
Tiny wrists. How old are you?
I'm 18.
18. Alright. Okay, right over here. Same thing. Step on in. Scoot over for me, please.
I tried to put
Two down.
Grades. The initial contact officer receives a B. The arrest was legally grounded and the scene was operationally coordinated. Asking about weapons before any physical search is a mandatory safety practice, and it was correctly applied here. Points deducted for transferring the disclosed knife to an unscreened third party, and for the absence of on-camera Miranda advisement. A procedural gap that creates evidentiary risk if statements are later challenged in court. The transport officer receives an A-. Restraint exchange, identity verification, and procedural notification were all executed correctly. The de-escalation framing was effective, if slightly informal. Courtney Chase receives a B-. She complied physically throughout. disclosed her weapon voluntarily, and did not resist, all of which reflect cooperative conduct that kept the situation from escalating. However, Chase did not invoke her Fifth Amendment right to remain silent. Her voluntary statements about her presence at the scene were legally unnecessary and potentially self-incriminating. Identity is required by law. Everything else is not.
Key takeaways.
For law enforcement, voluntary weapon disclosure does not authorize transferring that weapon to a third party at the scene. Retain all disclosed items and assess evidentiary value before any release. Administering Miranda rights on camera, not solely at booking, creates a documented record that protects the officer, the prosecution, and the integrity of any statements used at trial. The absence of that documentation is a recurring evidentiary vulnerability. For citizens, Florida law requires you to confirm your identity. Beyond that, the Fifth Amendment gives every person in custody the absolute right to remain silent, and that right does not expire because the setting feels informal. Statements made by phone to family after arrest are not shielded by Miranda and are not privileged. They are admissible. Say nothing beyond your name until you have spoken with an attorney. If you face a constructive possession charge, do not attempt to explain your presence or lack of knowledge to officers. That is a conversation for your defense attorney, not for the back seat of a patrol vehicle. Let us know if there is an interaction or legal topic you would like us to examine in the comments below. Thank you for watching, and don't forget to subscribe to the channel for more police interaction and courtroom content.